No. But we're going to get him discovery so he can prepare his exam. So you want the body cameras? What else you want?
We get it. I've never got.
But sir, everything is not specific enough for me to enforce. Arraignment papers are not part of discovery. Arraignment papers are court issue stuff. What he just gave you is written discovery. That means that's all the documentation they have. So anything you want that is not documentation, like a body camera, then you got to ask for that. So you've asked for the body cam. Is there anything else you want? That would be the written, wouldn't that be part of your written discovery?
It would be.
So any written documents, if it ain't in there, they don't have it. And if they come up with it at the exam, they can't use it. Follow me? All right. So other than documents, other than paperwork and the body cam, is there anything else you think you want? I saw you in here when I walked by and I thought the prosecutors were in here too. No, I just saw you there and I thought you were talking to them. So I figured they were already here. No, he's here. They brought him in. Yeah. Yeah. A lot of sirens out there today.
Thank you.
Gentlemen, People versus Shabazz.
I mean, we're waiting for Officer Fox. That's the problem. I'm good with this.
Have we heard from Officer Fox? This one was scheduled at 9.
Looking at the schedules.
Right?
9 o'clock.
Who'd we call?
Then I will call the supervisor.
I'll sit. I'll give him a chance to get a response. Let's find out what's going on.
But you guys step out and.
Yeah. And do you know are you handling the exam on Bradford?
Yes.
All right. And he's here. We got him in the building.
This is attorney check?
He doesn't have an attorney. He doesn't want an attorney. So buckle up. You spoke to Bradford?
Oh, I was just in the Zoom room while he was on the record.
Oh, was it a rodeo?
Yeah. He was on competent though. I did go back. Maybe I remember it because like he said something about competency, so I pulled the circuit court case up and she was determined competent in circuit court.
Yeah, I'm fine of saying when I'm king of the world, because when I'm king of the world, you know what the main criteria will be for competency to stand trial? Do you want to represent yourself? You're not competent.
Yeah. I had a 17-year-old in adult court. They stated incompetent, unrestorable yesterday. We finally all stipulated it, but that was second from forensic psychiatry, not even the person we usually hire.
Right.
They think he's 17, he'll never figure it out. And because he's 17, he has maybe has an intellectual disability, not a psychiatric.
Right.
The statute for intellectual disability says individual 18 or older.
Doesn't even apply to him.
So they just dismissed it. They spent 2 weeks researching it. They said we can't figure anything out, so it's just dismissed and you just go home.
Yeah. Yeah. Once again, they changed some laws here, and they don't.
They didn't think about anything else. If it was just stayed in juvenile court, they would do a hearing.
Yeah, whole different ballgame. Because they were ready for that, right? They've done that before. So much of what they do in Lansing has unintended consequences because they don't think things through.
No, not. But yeah, I don't think that exact set of circumstances will ever happen.
No, it's pretty strange. Pretty strange.
Yeah.
Joe. Is Bradford upstairs or downstairs? Upstairs.
Have you been up in months since Susan? Did your friends go? Oh, good.
We're supposed to go up this weekend. We got 6 of us be up there Friday. I'm going up early, so I pick up the trees. We ordered a bunch of seedlings. And we got 400 seedlings to put around side of
What?
it. It's doable. If the guys don't, like get exhausted out there or something. But I just got an email, mass email about everybody that ordered trees, and they're talking about some containerized trees not being available till next week. So I'm like, I need to know if my order is available, because I got people coming up, so you check my order, tell me if you got enough for my order.
Are they looking at trees?
Seeds, mostly conifers, but some oaks, mostly conifers.
And what is the good news, Mr. Kaplan?
Spots no longer is employed by the police agency, therefore, we won't be able to produce them this morning. We'll be authorized a case mention.
Understood? Dismissed without prejudice. Did you post any cash bonds, sir? No cash. Okay, you're free to go then. Thank you.
Thank you.
Are you ready on Bradford?
Oh, you already got it. You knew it.
Yeah, we'll get a copy of the ROA or whatever we do. Right, Marianne?
They have who's on Saturday very soon, so I just want to make sure.
He's got a tether, so he's got to have some paperwork to get the tether off.
Thank you.
All right. Yeah, round him up. Bradford's right off the room here.
No, I have a sick right there, I'll bring you some paper, okay?
It'd be like that. Yeah, wait. Oh, yeah. Take that. Well, I'll have it for you.
As we want.
Yeah, you might as well bring him in.
He's out alcohol.
I don't know if it's GPS or alcohol.
How are you?
Interesting.
Here, I got mine right here.
Well, thank you.
You wanna, I don't think there's anybody at the kiosk. You need the Belleville cop in here? Steve,
Officer Pearl. He should be.
hey, would you send the Belleville cop in here off the Pearl? Thanks. Mr. Bradford, have a seat, sir. Good morning. And Mr. Kaplan, are you ready?
We are doing things, we got one looking at Indiana.
All right, go ahead.
Judge, in this case, as you know, the defendant has been charged with third-degree fleeing and eluding. We actually undercharged him. He committed allegedly fleeing and eluding third, and with the prior conviction, it becomes fleeing and eluding second, which is a 10-year felony as opposed to the 5-year felony.
And
Therefore, at the conclusion of the exam, I will ask the court to bind the case over on fleeing and eluding second.
okay, Mr. Bradford, you understand what he just told me?
Yes.
All right. Are you ready to proceed, sir?
No, I was waiting for my. Sorry.
I don't know what that is. I don't know what you're asking. I don't know what you're waiting for.
See myself.
Okay, any discovery? Okay, all right. Did you have a discovery order? Have you made a formal request for discovery? This is the first time I've seen this file, so I don't have any background on it.
I mean, he told
That's all right. Take your time.
my things to, basically, stimulants. I was just.
Your entire permission to speak to the defendant and wind up possible any piece of charge, it might change the equation for him like the whole.
Sure. You mind having a discussion with Mr. Kaplan about what options are?
clearly said in the ROA that the attorney was instructed to turn over discovery.
Maybe he did, you don't know.
I don't know who the attorney is. I know the quality of people you've got doing this work.
No.
You know, the quality of people that are doing this work. We've got some things. We've got some fantastic attorneys, and we've got some that just going through the motions.
I think that our prosecutor, could you just sign the bottom of it?
Going through the motions.
Yeah.
Collecting their paycheck.
Like going through the motions.
Unbad.
Mr. Kaplan,
They can answer the question, original attorney for me,
yeah,
attorney William Oaks court of claim. Apparently there was some disagreement with William Oaks banished from the case, replaced by Rodney Williams. Your Honor, discovery was provided to William Oaks. And then we sent an email today, the last few days, to the second lawyer, Rodney Williams, letting him know that the case is upcoming and, please provide.
who was here last week when Judge Patton said provide two?
I wasn't following the case at that point. You really want.
All right,
But I do know that we've said that we can copy the email from their staff and everything.
all right. So we got to adjourn it because we got to get directed to him.
I do have a police report, Joe, can I give my copy?
Okay. Do you want more than the police report? You're going to have to tell them what you want. They don't know what you want.
Stands on May 12th.
Say it again.
12th at 9 is the next opening.
For who? It's not my case.
Or if
It's yours.
It's gonna stay with us,
I'm just covering because she's not available today.
but that's the next opening
For
for anybody.
yeah, and that's the way we're doing it. Clear?
Your Honor, I'm gonna give a copy of the paper discovery.
Okay. Yeah, I was having my own conversation about scheduling. So what else do you need besides that?
I don't have a video with me, Joe.
No. But we're gonna get him discovery so he can prepare his exam. So you want the body cameras? What else you want?
Everything's from the beginning, I never got.
But sir, everything is not specific enough for me to enforce.
Work. I understand.
Well,
Arraignment papers are not part of discovery. Arraignment papers are court issue stuff.
Tickets. Anything, no, like,
They're,
further along in this case, we'll have to.
what he just gave you is written discovery. That means that's all the documentation they have. So anything you want that is not documentation, like a body camera, then you got to ask for that. So you've asked for the body cam. Is there anything else you want?
Witness statements.
That would be the written, wouldn't that be part of your written discovery?
it would be,
So any written documents, if it ain't in there, they don't have it. And if they come up with it at the exam, they can't use it. Follow me? All right. So other than documents, other than paperwork and the body cam, is there anything else you think you want? Okay, now here's the problem. They usually email digital discovery, right? Okay. Do you have access to that kind of equipment in the jail so you can get it?
No, sir.
Then you can't get discovery. I'm not going to order them to walk down there and hand you a laptop at the jail. That's not what the prosecutor's office does.
There's one that's, I'm working on it also is. Since this is taking so long, I'm quite sure I'm gonna be, released on that case by the time they send it.
All right. Are you being held on this one? What's your bond on today's file? Do you know? Okay. All right. So do you have any idea when that's going to be resolved? The other case?
It's, I'm waiting on these two cases are coinciding with each other. This one sold me up for that one, that one sold me up for this.
Well, I can give you a new date for an exam on this one, but we still got to get your discovery before that new date. So how are you going to get your discovery? I just asked you that. So if if you give an email address and they email that digital discovery to you, you'll get it.
I'll get it, but I have to be able to see what I got to tell. Can't get it from the else.
But that's what I'm telling you. You're telling me you can't get out of jail until this case is over. This case ain't over until the exam gets done.
Just because I go back to court, show them the progress of this. That's all he wants to see.
Okay, so when are you going back to court on the other one? Sure.
You don't need my help serving as
No, go ahead. I'm always looking for help.
the discovery. It's not our fault, not your fault that he fired 2 lawyers. Judge, now he has the paper discovery. He can read them in the next hour if you don't mind. We're not introducing body camera evidence, therefore he has no grief at this point.
So you're going just on officer's testimony for PC purposes. All right, so let's try that. You understand what the purpose for this exam is, right? It's not for them to prove to me you're guilty or not guilty. You understand that? Today is just probable cause. They got which is a pretty low burden. I keep saying prosecutor has to convince me 2 things. 1, that a crime occurred, and 2, that looks like, there's reason to believe you were involved in the crime. You understand that's the burden?
Yeah.
It's a yes or no question, Mr. Bradford. Do you understand the burden? Okay, so what he's telling me is video's not coming in today. He's just going to put that guy right there on the stand, ask him some questions, and establish some facts through his testimony. Okay? I'm assuming, is that your report that he's holding in his hand, House Pro? All right, so his report from the incident is what you've been given. So today, we probably don't have to get into digital discovery. We can get through today, then you'll have something to talk about at your next case.
No, that's the right officer. That was on his face. I don't know.
We're saying it is.
So you kind of
Michael Burke.
I don't know if it is either. I wasn't there. But that doesn't change what I'm talking about. So his suggestion is I hold for a minute, just pause. We'll put you back in the cell, give you some time to, digest that paperwork in your hands. And then we'll come out here and we'll do a probable cause hearing, not a trial. And then at least we can accomplish something so you're further along when you go to your next case, and hopefully you're that much closer to being on the street before this trial comes up downtown.
Something that pretty off of this.
Okay, did what I just say make sense to you?
I don't know. So we'd like to be adjourned, so I can get everything, so I have everything,
We have opposed the motion.
I understand that, but you can't give me a viable way for you to get everything. Everything includes the video footage, right? You're telling me you can't get your eyes on the video they email you until you're out of jail, but you can't give me any idea when that's going to be. Am I missing something? I'm sorry?
You gave me a week, so get everything done.
The court date on the other file, you mean? And you think they're going to release you? What if they don't? Then what?
We're ready to proceed now. We have our witness.
I'm going to hold it, Mr. Bradford. You can appeal me. I'm going to hold it. You want some time to review the paperwork before we hold it? Okay. We'll do that. This case is in recess.
Thank you.
All right. Pause. Just. Mr. Bradford, just so I can tell everybody when we're likely to get going. How much time do you think you need before we're ready to go? It's 10 o'clock now. 10:30? Okay. All right. Just so we can all plan. Thank you.
All rise. Bridgeport District Court back in session. Honorable Judge Oakley presiding.
Have a seat. Have a seat. I have yet to find anything that works on this one. Are we ready? Okay,
Hey,
all right, let's call a witness.
Michael Pearl.
Officer, come on up. Raise your right hand for me. Swear or affirm, tell the truth, the whole truth, nothing but the truth. Watch your step on the ramp. Have a seat in that chair. When you get over there, hand me that box of Kleenexes.
Sure.
I don't expect you to get a little weepy today.
Thank you.
Thank you.
Yeah, Your Honor.
Yes, please.
Hey, Your Honor. Morning, Officer Pearl.
Morning.
Sir, how many years have you worked as a police officer?
About 6 years.
Taking you back to June 22nd, 2024, at about 11:20 at night. Were you working?
Yes.
What were your responsibilities, Officer Pearl, on that evening?
Go, respond to calls and perform my regular duties.
Were you in a vehicle or were you stationary?
I was in the vehicle.
Marked and unmarked vehicle? Were you in uniform or plain clothes? Officer Pearl, on that day, June 22nd, 2024, did you meet a gentleman named Daniel Bradford?
Yes.
Is the son of Bradford executive? If you want to go and you check, hopefully you know what we speak.
Very good.
Let's see where.
We're green.
Your Honor, may the
Sure.
record reflect the witnesses identified the defendant, Mr. Bradford.
Noted for the record.
Are you referring to the,
Well, you said you met a man in this.
okay, yes.
So what caused you to interact with them or notice?
I attempted to pull him over. I'm traffic stop.
In the vehicle or was he walking?
He was in the vehicle.
You remember the vehicle?
Yes.
What model?
It was a Chrysler Town and Country.
You remember what color?
Purple in color.
Was he alone or did he have an occupant with him in the vehicle?
He had a single pass.
Was Mr. Bradford driving or was he the passenger?
He was driving.
What did you notice about his driving?
I noticed that he disobeyed a stop sign and failed to signal his turn
On what street did that occur?
at the intersection of Belleville Boulevard and Sumter Road,
In what community?
the city of Belleville.
What else did you notice about Mr. Bradford's driving?
I observed that after I had activated my overhead lights, his speed increased significantly.
What does that mean he was a police officer?
He was attempting to flee or elude me.
Officer Pearl, when you first noticed the defendant and he disregarded the stop sign, were you next to him, behind him, or in front of him? In front of his vehicle.
I was, he was coming at me, so we were, he was the front.
Where was your vehicle when Mr. Bradford began to drive at a higher rate of speed?
I'd say in the area of Sumter Road and Owen by 600 Sumter.
Your Honor, I would like to address the court and say that request earlier to increase the charge, the defendant has enough pain later on that seek that increase.
Thank you. No problem.
Officer Pearl, when if at all did you attempt to make traffic stop? At what point?
I was passing the Belleville Plaza where Dollar Tree is on Sumter Road.
Can you estimate for his honor the amount of time or the distance you spent pursuing this defendant?
About 3/4 of a mile.
What part of, did you have overhead lights and siren?
Yes,
Did you activate either or both or none of those items?
both.
Were they functioning?
Yes.
Did Mr. Bradford heed your request to pull the over?
No,
You remember the time this occurred?
this was just before midnight, I believe.
Officer Pearl, did you form an opinion one way or the other whether the defendant knew you were trying to pull him over?
Yes.
What's the basis for having an opinion? What is your?
Can you rephrase the question, please?
Sure. And you activated your overhead lights,
Yes.
and you said you didn't stop doing it.
Correct.
So about a mile,
Yes.
and you increased speed.
Yes.
Did you form an opinion whether he knew you were there trying to pull him over?
Yes. My opinion was he was actively trying to flee.
But sir, ultimately, Did you stop him?
Yes.
And when you stopped him, did you make any observations about his state of sobriety?
Yes.
What did you do which enabled you to detect and notice his state of sobriety?
As Mr. Bradford was exiting his vehicle, a partially full can of Corona beer fell out of his lap. As he was being taken into custody, I observed him having bloodshot, watery eyes, slurred speech, and he admitted an odor of intoxicants from his breathless swelling.
Did you inquire of him whether he had consumed any alcohol that late afternoon or evening?
I don't remember if we inquired on his alcohol intake that night.
Tell the judge the status of Mr. Bradford's driver's license on the name.
Revoked.
How do you know that?
His return in Lee was Lee said.
Now, without telling us the results, did you perform a PBT?
No,
Did you make any efforts to gain any blood or breath from him for analysis?
I asked him if he would be willing to submit to a chemical blood test.
What did he say?
He refused.
Well, did he submit eventually to a chemical blood test?
Yes, we had to get a search warrant.
Did you gain a search warrant?
Yes,
Do you remember from which jurors please community? Remember the judge?
I don't remember the exact judge. I'm sorry.
Where, are you with the one the blood is extracted?
Yes,
Where does that take place?
Orwell can.
Do you remember who extracted the blood or what type of position that person had?
I don't remember her name, but no, she was a registered nurse. I think her last name started with Billy, like that.
Now, what if anything did you notice about the defendant's breath?
It smelled like intoxicants.
Your Honor, at this point, I would move to admit proposal to the board if I may approach. I've shown a copy to the defendant.
Thank you.
Your Honor, what I've just tendered to the judge is the lab report issued on July 10 of 2024. Michigan State Police, its laboratory number, if I may, 2X24 9569. And the result of this blood analysis, according to Michigan State Police, legally Diane Bennett, forensic scientist, the defendant had blood alcohol level of 0.150. So with that, Your Honor, no further comment.
Are you moving for this to be admitted?
Yes.
Mr. Bradford, any objection to exhibit number 1 being admitted into evidence? Thank you.
Thank you.
Oh, you've already got it marked. Mr. Bradford, do you have any questions for Officer Pearl, sir?
Yes,
Okay. You can stay right there or you can come up at the podium, either one.
you said in the report that you were posting in front of the vehicle down some road. You initiated lights, rushing up.
No, I initiated my lights after you passed me. I had to turn around, so I was behind you when I initiated my emergency lights.
So then how far was it between the place where you had the U-turn?
Yeah,
How far was that between the time you took the major U-turn?
it was fairly quick. It was, I turned around and I exited my lights shortly thereafter.
So would you say the car was speeding already, or was it fleeing from once?
No, your speed didn't increase until I turned on my lights.
Well, the question was the car already speeding, or
No.
you think that the car was speeding or already fleeing before it stopped?
Let me stop you because I'm confused by the question. I think what you're asking him is, did he think you were traveling over the speed limit before he got behind you? Is that what you're asking him?
Far as the fleeing and moving.
No. Just, is that the question you want to know? Did he think you were speeding while you were still approaching each other? Is that the question? At that point, while you're still approaching? Okay, you understand that question?
I don't believe you were, no. I mean, technically, you can't even be fleeing if my lights aren't activated. So,
That answer the question? Okay, any other questions?
Yes, one other. So after you stop the car, you didn't have, footage on your camera. Stop.
I have footage of the entire incident, yes. Yes.
Any other questions? Okay, any follow-up?
Yes.
Yeah, go ahead.
You mentioned to the judge about the stop sign violation. Did the defendant commit any other civil infractions in your presence?
He failed to use his, turning signal when he was turning on the Sumter Road from Belleville Boulevard.
Lastly, can you tell the judge the speed limit of the beginning area, beginning time when defendant fled to when you finally pulled him over? You know what his speed was?
So, when he initially started fleeing, the speed limit was 40 miles an hour and he was traveling upwards of 68 miles an hour. And when we
Was
crossed,
the speed limit ever diminished before he was finally pulled over?
yes,
What's the speed limit in that area where you finally pulled him over?
in the area from, the train tracks to, where he eventually stopped his vehicle, it's 30 miles an hour.
Thank you so much. Nothing further, Judge.
Any follow-up questions? Yeah, go ahead.
So, the road you said was Belleville Boulevard.
Yeah,
How far is that from the initial stop? How far is that from when we took the route?
Let me stop, because once again, I want to clean up your question. I think what you're asking is from where you pulled out onto Sumter Road to when he did the U-turn, how far is that?
Yes. We seen.
Okay, one at a time. Okay, approximately how far between Belleville Sumter intersection and where you did your U-turn?
less than a quarter mile.
Okay, now the follow-up question would be,
Safety broker, stop before, and all of that from front where we were on.
Yeah, I didn't observe, no.
So they would,
I did not observe you use a turn.
so, orders.
no, I don't think, he said, I did not see you use a turn signal.
Oh, that's all.
Your question is, could he see
Yeah.
that distance?
Yeah, I could see the lack of the turn signal use, yes.
That's it? All right, Officer Pro, you can step down. Watch your, thank you. Watch your step on the ramp. All right. Okay. Are we ready for argument? Go ahead.
In this case, we have proven to you that the defendant drove with an unlawful blood alcohol. We've also proven to you that he was driving while under the influence based on the observations made by the officer. Your Honor, the speed limit in part of the area where defendant was fleeing is 35 or less. So that would enable us, if it's fourth degree fleeing, to be third degree fleeing. It also becomes third degree fleeing because defendant was a crime of conviction for fleeing and looting, which is part of the packet. We believe probable cause has been established that defendant committed count one, Your Honor, fleeing and looting third degree, count two, OWI third, death penalty, private license, piggyback, 1, 2, 7. We respectfully would seek a fine over judge on the 3 counts.
All right, Mr. Bradford, any argument?
Keep that up, just looking at this. It's story mechanisms. Not very fulfilled time. If fulfilled was it, we should have more before.
Okay, well, you'll probably have more before it's time for trial if that's where this is headed. But my question is, do you have any argument to the bind over in response to the argument Mr. Kaplan just made?
Yes, that's what, go in there, it's happening.
I'm sorry, say what? This is a preliminary examination. Yeah, this is the probable cause hearing today. What we just did was a preliminary exam.
Sorry about that. I'll see that and prove that this is fine, this is legal. Going on, see my name's not, stars out my name, and a single footage of me driving.
Okay, anything else? Okay, so as far as identification, the officer's testimony is enough for probable cause to establish your ID. So I'm gonna bind you over on counts 1, 2, and 3. We'll send you downtown for the next step of the proceedings. The next date is the arraignment on information, which will be next Tuesday at 9 o'clock at the circuit court level. Do you have any questions about that process? All right, I'll continue your bond. Anything else?
No, thank you.
Mr. Bradford, please listen to me. Do yourself a favor, take advantage of the court-appointed attorneys. Dude, I mean, you did a decent job with your questioning today, but you're so far over your head on this thing. All right? I tell people all the time, I don't care if you're the smartest guy in the room right now. You still don't have the training and the experience to represent yourself. I know real good attorneys that don't represent themselves when they have problems. Take advantage of the attorneys. Do yourself a favor. I'll sleep tonight. Good luck downtown. Thank you, gentlemen. Be safe, officer. Thanks, Mayor.
I'll take the file.
Thank you.
I hope he listens to you.
He probably won't. I hope he does too. Just makes things so much easier for everybody else and it's better for him. Then what is that, 28th?
One of it was my fault. It's just what I'm saying.
Give me a minute for the,
Oh, here- hey, would you take his exhibit back to Steve Kaplan? Oh.
To the office, so the fire chiefs get on the feet.
is it open?
Yeah. They've officially moved in about a.
Is it the old thing or the
It's the old post office. Yeah, it's on Charles Street. It's real close to the library.
Yeah.
But it's not, it's like a whole lot. I told this, man, sitting there, walking around, like, they've got a, you know, it's just.
Oh,
it's
that.
all the Indian camera had these.
It's always been there since I've been.
Always
I've
been
been
showered. Yeah, they never make showers.
Can you imagine? Now they can go out to the dryer, you know, something happens, they want to go wash their uniform before they go out on the road or something.
This courtroom exchange started like any other hearing, but it slowly turned into a harsh reality check. The defendant stood alone, no lawyer, trying to handle everything himself. At first, it seemed like he believed he could manage the situation. But as the hearing moved forward, the cracks started to show. The judge kept things calm, but extremely direct. He explained step by step what was actually happening. This wasn't a full trial, just a probable cause hearing. The bar was low, and still, the evidence was stacking up fast. An officer took the stand and described the entire situation. Late at night, a traffic stop attempt, and then suddenly, the driver speeds up. Lights on, sirens active, but instead of stopping, he keeps going. The officer testified that the defendant was clearly trying to flee, and when the stop finally happened, things got worse. Bloodshot eyes, slurred speech, the smell of alcohol, and even a beer can falling out of the vehicle. Then came the lab result. Blood alcohol level at 0.15. That's nearly double the legal limit. The defendant tried to question the officer himself, but it wasn't enough. The judge stepped in multiple times just to clarify basic questions. And that's when the reality hit hardest. The judge told him straight, "You did okay, but you are way over your head. Even experienced lawyers don't represent themselves in serious cases." And right there, the judge gave him advice that most people ignore. Take the help that's offered, because trying to fight alone can cost you everything. In the end, the decision was clear. Probable cause established. Charges move forward. And one message stayed behind. Confidence without knowledge can destroy you faster than mistakes ever will.